Since we all know that Justice N. Kumar is extremely popular in the way he makes us understand the nuances of any topic on which he gives his insight. And without taking much time, I would request Justice N. Kumar to take things forward from the previous session so that people could be more enriched with knowledge as usual after your session. Over to you, sir.
Thank you. Good evening to all. Today we are looking at a civil trial. Now, when can you say a civil suit is ready for trial? Because before the trial commences, there are several stages have to be gone through before we could say a civil suit is ready for trial. On the last occasion, we saw the scope of pleadings: plaintiff, plain, written statement, counterclaim, additional written statement. That is, once all the pleadings are over in a civil case, the next stage would be framing of issues. Once the issues are framed, it is clear what are the things which are admitted in the pleadings, what are disputed, and the plaintiff who has come to court to succeed, what is that he has to prove, because the defendant has denied his claim. So the issues will show on whom the burden of proof lies to prove a particular fact which is in dispute. In a given case, all the issues, the burden of proof may be on the plaintiff. In some cases, few issues will be on the plaintiff, and few issues, the burden of proof will be on the defendant. There may be some exceptional cases where all the issues are the defendant. Take a case of discharge, in which event there is nothing for the plaintiff to prove, because the defendant admits his case and he says he has discharged his liability. Then the burden of proving the discharge of the liability is exclusively on the defendant, and the defendant fails, suit is decreed, otherwise the suit is dismissed. Therefore, when we say the suit is ready for trial, it presupposes pleadings are complete, issues have been framed, and all the documentary evidence on which the parties rely on are before the court. Similarly, if the parties intend examining witnesses other than the parties, a list of witnesses is also filed, and then the suit is ready for trial. This commencement of trial and examination of witnesses in support of the claim or the parties is contained in Order 18 of the Civil Procedure Code. It has a heading, that is hearing of the suit and examination of the witnesses. Order 18 Rule 1 speaks about right to begin. There are two parties, there are three parties in a suit. Who is that person who has the right to begin the trial? Order 18 Rule 1 clearly mandates that the plaintiff who has come to court has the right to begin unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which case the defendant has the right to begin. Therefore, law is very clear. Merely because the plaintiff has filed the suit, it is not as if that he alone has the right to begin. So ultimately, it depends upon the issues, the burden on whom those issues lies. And as I said, if the defendant were to admit the claim of the plaintiff and plead discharge, then the right to begin lies with the defendant. But generally, we see it is the plaintiff who begins the trial. Let me point out at this juncture, this trial in a civil suit or even in a criminal court is a very most important facet. And it is here the ability of a lawyer, the competence of a lawyer is tested. In fact, if you were to go to sit in a court of law and try to find out what's happening, today it's very difficult to make out anything because we are not following the Civil Procedure Code. Civil Procedure Code is such a beautiful piece of legislation. Not only it gives us the procedure, it makes the trial very interesting. I'm sure I have not come across a case where these provisions, the beauty of which would be added to a trial, unfortunately is not followed in day-to-day working of the courts. Order 18 Rule 2 speaks about statement and production of evidence. Statement and production of evidence. What it says is, today the plaintiff simply puts the witness in the box and starts his evidence. If anybody is sitting in the court hall, including the judge, who does not know what the case is, but what the law expects from the lawyers who are appearing for the parties is, before you put your witness in the witness box, if you have really made preparation, a good preparation, you should be able to tell the court in a nutshell what the case is about, what is the crux of the matter, what is to be proved, what he intends to prove it, and how he is going to prove it. All this should be stated in 5 minutes. That is possible only if a lawyer has applied his mind, made full preparation, and he knows what the law on the point is, and then he enters the court hall with the witness and puts the witness in the box. Order 18 Rule 2 states, on the day fixed for the hearing of the suit, or on any other day to which the hearing is adjourned, the party having the right to begin, shall state his case, not put the witness in the box and through him you speak. No. He shall state his case and produce his evidence in support of the issues which he is bound to prove. Therefore, broadly he must say, this is my case. This is the evidence I intend producing. These are the number of witnesses I am going to produce who speak to these facts. And this is the documentary evidence. That will give the judge and anybody who is sitting in the court hall and observing it, what the case is about within 5 minutes. Once the plaintiff's counsel finishes these submissions, the other party, that is the defendant's counsel, shall then state his case and produce his evidence, if any, and may then address the court generally on the whole case. Of course, the party beginning may then reply generally on the whole case. So this is broadly the scheme of a trial found in Order 18, Rule 2 CPC. As I said, in a suit there will be several issues. Now, if in some issues the burden of proof is on the plaintiff, on some issues the burden is on the defendant. In such circumstances, how do you adduce evidence? That is spoken to by Order 18, Rule 3. It says, where evidence is required to be produced on several issues, where there are several issues, the burden of proving some of which lies on the other party, the party beginning may, at his option, either produce evidence on those issues or reserve it by way of answer to the evidence produced by the other party. And in the latter case, the party beginning may produce evidence on those issues after the other party has produced all his evidence, and other party may then reply, especially on the evidence so produced by the party beginning. But the party beginning will then be entitled to reply generally on the whole issue. That is, there are 5 issues in the suit. The burden of proving the first 3 issues as on the plaintiff. The burden of proving the other 2 issues on the defendant. Take, for example, the plaintiff is claiming title to a property by inheritance. The defendant has set up a will. The burden of proving the will is on the defendant. If there is no will, by inheritance, the plaintiff succeeds to the property in a particular share. If the property is a self-acquired property, if the person who owned that property has died, testate, then it comes in the way of natural succession. Therefore, in-law is entitled to the party, subject to the condition, if the will is proved, the plaintiff is not entitled to that property. Now, he has to need evidence on the first 3 issues, maybe nature of the property. In law, he has an option not to say anything on the question of will, which is set up by the defendant. After completing his evidence on 3 issues, he can always request the court that he reserves the right to lead evidence on the other 2 issues after knowing what is the evidence the defendant is going to adduce on the issues. So after the defendant adduces the evidence on those 2 issues, again, he can produce evidence to disprove the case of the defendant. This is precisely what Order 18, Rule 3 says. But in practice, though the sections say so, how do you reserve your right? That is not specifically stated in the Civil Procedure Code. But over the years, the practice which has developed is, if the plaintiff wants to reserve the right to lead evidence on issues on which the defendant, burden of proof is the defendant, after completing his evidence, he is expected to file a memo to the court reserving his right to lead evidence on those issues. The burden of proof is on the defendant. A memo is sufficient. If a memo is filed, it is taken on record, it is recorded in the order sheet, and then the defendant leads evidence. And then, because of the right reserved, plaintiff will be called upon to adduce evidence insofar as those 2 issues are concerned. But if the plaintiff is so confident that he will be able to disprove the case of the defendant without reserving, he can straightaway lead evidence not only on those issues, the burden of proof is on him. He can also adduce evidence in respect of those issues where the defendant has to prove the case. That's why I said an option is given to him. How to exercise the option? The way they exercise the option is file a memo after you complete your evidence, before the defendant commences evidence, stating that he reserves the right to lead evidence on those issues, and that would serve the purpose, and that would be that would satisfy the requirement of law. Now, earlier, before 1976, the procedure was you go on examining witnesses endlessly, and then the parties enter the box in the end. It was found most of the time the court will never know what is the case of the parties. Therefore, in 1976, an amendment was brought in, and Section Order 18, Rule 3, capital A was introduced. The object of this amendment was to see that the parties give evidence first, and then the witnesses would enter the witness box. So therefore, Order 18, Rule 3A said, where a party himself wishes to appear as a witness, he shall so appear before any other witness on his behalf has been examined, unless the court, for reasons to be recorded, permits him to appear as his own witness at a later stage. So therefore, now the law is very clear. When the plaintiff is called upon to lead evidence, when he has the right to begin, the first person to enter the witness box should be the plaintiff and plaintiff alone. But if there are some reasons, good reasons, where he cannot enter the witness box, what he is expected to do is he has to file an application to the court, bringing to his notice the circumstances which prevent him from entering the witness box, and request the court to permit him to be examined after the examination of witnesses. And the court, for reasons to be recorded, grants him the said permission, then in such cases alone, the witnesses could be examined first, and then the party could enter the witness box. So what applies to the plaintiff equally applies to the defendant. A good deal of thought has gone before this provision was introduced, having regard to the way earlier the provision of leading evidence was abused. Now with this introduction of the amendment, today when the party enters the witness box, gives evidence, we will come to know only which part of his case is to be proved by a witness, and only those witnesses are examined. Therefore, is a factor which has to be kept in mind when you are ready for trial. Whether are you going to put the plaintiff first in the box? If for some reason you are not able to do it, you have to file an application, request the court to permit him to be examined thereafter. So this is the preparation you have to make before the trial takes off. Now, when we are talking about the examination of witnesses in a court, you have to read these provisions of the Civil Procedure Code with the provisions of the Evidence Act, which also deals with examination of witnesses. You have to synchronize both these provisions. So what does the provisions of the Evidence Act speak about the examination of witnesses? Section 135 of the Evidence Act specifies the order of production and examination of witnesses. Order of production and examination of witnesses. It says the order in which the witnesses are produced and examined shall be regulated by the law and practiced for the time being relating to civil and criminal procedure respectively, and in the absence of any such law, by the discretion of the court. So Evidence Act does not lay down any rule. It says you go by the law of the land. If it is a civil case, civil procedure. If it is a criminal case, the criminal procedure. So we saw in the civil court how witnesses have to be examined. Parties to be examined first, and then witnesses have to be examined. That is the order specified in the Civil Procedure Code. Now, when we are talking about examination of a witness, it is not as if the parties are free to enter the witness box and say whatever they want to do and produce whatever the document they want to do. For an orderly trial, Section 136 of the Evidence Act confers a power on the judge to decide as to the admissibility of evidence. It is only the evidence which is admissible which can be adduced, and the judge has the power to reject the evidence which is not admissible in his view. It says when either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant. And the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant, not otherwise. Therefore, if a doubt comes to the judge, if you have to ask a question, you are leading this evidence, how is it relevant? A duty is cast on the party and his counsel to explain to the court what is the relevancy of that particular evidence. If he is not able to satisfy the court, the judge is at liberty to reject it. And what is relevancy? You look into the Evidence Act, it speaks about what is the relevancy. Otherwise, the trial would lose its meaning. You cannot go on saying it's not a question of exercising your fundamental right of freedom of speech in the witness box. It is regulated by certain rules. Yes, you have the liberty to give evidence, burden is on you, but the evidence you are going to adduce in support of your case, in proof of a particular issue, should be relevant to the issue in fact. Otherwise, the court has the power to reject it outright. Now, Section 137 specifically says how this examination of a witness is to be done. It says the examination of a witness by the party who calls in shall be called his examination in chief. Then it also defines what is cross-examination. The examination of witness by adverse party shall be called his cross-examination. Then, what do you mean by re-examination? The examination of witness subsequent to the cross-examination by the party who called him shall be called as re-examination. Therefore, Evidence Act specifically says what is examination in chief, what is cross-examination, what is re-examination. Then section 135 speaks about the order of examination. When should be examined chief, when should be cross-examination, when should be re-examination. It says witnesses shall be examined in first examined in chief, Then, if the adverse party so desires, cross-examine, and then if the party calling him so desires, is re-examined. Further, it says the examination and cross-examination must relate to relevant facts, but the cross-examination need not be confined to the facts to which the witness testified on his examination in chief. Now here, what is to be remembered is, what do you mean by evidence? Mere examination in chief is not evidence. If a person is examined in chief and the opposite party want to cross-examine, he must have sufficient opportunity to cross-examination. And only if he cross-examines the witness, that evidence which contains examination in chief and cross-examination is called as evidence which the court can look into. If after examination in chief, for cross-examination, the witness is not available, then that examination in chief is no evidence at all. It is only the evidence in examination in chief which is tested by cross-examination would be evidence admissible in court. Now, as far as this cross-examination is concerned, as aforesaid, it must relate to relevant facts. But in the case of cross-examination, some more leniency or some more liberty is given to the person who is cross-examining. What is that liberty which is given? When he cross-examines, it need not be confined to what the witness has said in examination chief alone. You may put questions to find out his veracity. You must put questions to find out his background. You must put questions to find out his experience. So, the cross-examination need not be confined only to what the witness has said in examination chief. It can be little broader, because one of the argument of the opposite party would be the evidence of the witnesses cannot be relied upon for the following reasons. He is not truthful. He is not a person who can be trusted. Please see his past record, or he is innocent. He has no personal knowledge. So in order to develop an argument of that nature, there must be evidence. And therefore, in cross-examination, it is permissible to put questions to a witness apart from what he has said in examining chief. Now, as far as re-examination is concerned, it should be directed to the explanation of matters referred to in cross-examination. In examination, he said, witness has said something. In cross-examination, you put question, get him confused, and he gives some answer. There is an ambiguity. So, in re-examination, that ambiguity, confusion, if any, could be clarified. But instead of clarification, if you want a fresh answer, it is permissible. That is, when new matter is introduced in re-examination, it is permissible if the court grants the permission. And if new matter is introduced by way of re-examination, then the opposite party will have the right to cross-examine upon that matter. So these are the limitations which are on re-examination. So examine chief, cross-examination, and re-examination. It so happens in the case of examination, sometimes you summon a document. So a person from an office brings the document. Now you must be very clear whether you want the document to be summoned or whether you want to examine the person who brought the document. Therefore, Section 139 of the Evidence Act speaks about what is known as cross-examination of person called to produce a document. A person summoned to produce a document does not become a witness. You have summoned a document, it has come. That's the end of the matter. So therefore, a person summoned to produce a document does not become a witness by the mere fact that he produces it and cannot be cross-examined unless and until he is called as a witness. Therefore, if you are summoning a person to produce a document, before you summon him, you must make up your mind whether he is called upon only to produce the document or he is called upon to produce document and give evidence as a witness. Only if he has been called upon to produce document and give evidence, he could be examined and cross-examined. Otherwise, by simply producing the document, taking an acknowledgement, he goes out of the court and there is no scope for cross-examination. Another important aspect which the lawyers should bear in mind is when you are asking a witness in the witness box about facts which are reduced into writing, now the question is it permissible to cross-examine them unless the document is before the court? Section 144 of the Evidence Act speaks about that. Any witness may be asked whilst under examination whether any contract, grant, or other disposition of property as to which he is giving evidence was not contained in a document. And if he says that it was, or is about to make any statement as to the contents of any document, which in the opinion of the court ought to be produced, the adverse party may object to such evidence being given until such document is produced or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. In other words, when oral evidence is adduced, that oral evidence does not include the contents of a document. In fact, oral evidence, contrary to the contents of a document, cannot be given. You have to read this along with Section 91 and 92 of the Evidence Act. But if a contents of a document become the subject matter of evidence, then the document itself should be produced and the other party can object, saying he should not be permitted to give evidence, oral evidence in respect of the contents of a document, and if objected to, the court is justified in upholding that objection. So now, this is broadly the scheme of the persons to be examined as witnesses. Scope of cross-examination, re-examination, and examination. Unfortunately today, after the 1999 amendment, this entire concept of examiner-in-chief has undergone a total change. Today, in court, especially of the party, there is nothing like an examiner-in-chief that has been substituted by an affidavit. So therefore, the party, when he enters the witness box and he is expected to give evidence, his examiner-in-chief will not be recorded with the court. It will be in the form of evidence, in the affidavit. Now at this juncture, when you are expected to file an affidavit by way of examiner-in-chief, another thing which the lawyer must keep in mind is the evidence to be adduced is of two kinds: oral evidence and documentary evidence. The examiner-in-chief can only be regarding oral evidence. Insofar as documentary evidence is concerned, document itself is to be produced. So when you are leading both oral and documentary evidence, the first and the foremost thing which has to be kept in mind by the lawyers is the law on the point, which is embodied in the Evidence Act. You are needing evidence for what purpose? To prove a case. Section 58 of the Evidence Act says, facts admitted need not be proved. There is no point in your needing evidence on matters which are not in dispute. That is a very sound principle which is found in the Evidence Act, which should be followed by the courts. No fact need to be proved in any proceeding if the parties thereto or agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading enforced at the time they are deemed to have admitted by the pleadings, provided the court may, in its discretion, require the facts admitted to be proved otherwise than by such admissions. So, the fundamental principle is facts admitted need not be proved. The facts may be admitted in a written statement. Facts may be admitted by writing before the trial, and even at the trial, the parties could admit on these issues there is no dispute, and let the court concentrate only on disputed facts. So, generally speaking, on admitted facts, neither party need produce any evidence, oral or documentary. At the same time, it is not a matter between two parties. If they were to collude, the court is not helpless. Even if they say it is an admitted fact, if the court is not satisfied about it, the court can call upon the party who has come up with a case to prove by independent evidence his case and not to depend on only the admissions. So therefore, admissions bind the parties and it does not bind the court. Court has the discretion either to act on the admissions or call upon the party to prove by independent evidence what the parties have admitted. Now, when we are talking about oral evidence, few facts have to be kept in mind. When we say oral evidence, it is not as if the witness can enter the witness box and go on saying something. Whatever he utters is not oral evidence. Whatever he utters in the witness box is not oral evidence. Section 59 of the Evidence Act clearly sets out in law, in Evidence Act, what do you mean by oral evidence? Because we are in a court of law. We are bound by the procedural law. We are bound by the adjective law. We are bound by the substantive law. So, the entire trial to be conducted should be in accordance with law. And what is that oral evidence is clearly set out in Evidence Act, which the courts and the parties are bound to follow. So, when you are trying to prove a particular fact, which is in dispute, by oral evidence, what is that oral evidence which has to be adduced? What is that oral evidence which the court has to look into to find out whether the plaintiff has proved his case or whether the oral evidence produced is not sufficient to prove his case so that it can hold as not proved, or when the opposite party gives oral evidence to disprove the case of the plaintiff, the court can record a finding that the case is disproved. So, when the court says prove, not prove, disprove, on the basis of oral evidence, the question is, what is that oral evidence which the parties are expected to produce? That is contained in section 59. It says, all facts except the contents of documents or electronic records may be proved by oral evidence. All facts may be proved by oral evidence. All facts except the contents of documents electronic may be proved by oral evidence. Now, what is to be proved is a fact, and every fact except the document or electronic record can be proved by oral evidence. Now, when we talk about oral evidence, there are several types of oral evidence recognized under the Evidence Act. That you will find it under section 60. It says the first principle to be remembered, both by the lawyers and the judges, is the oral evidence which you are talking about must be direct. Oral evidence must be direct. What do you mean by direct? Oral evidence must, no discretion, must, in all cases, whatever, be direct. Be direct means what? That is to say, if it refers to a fact which could be seen. If it refers to a fact which could be seen with your eyes, it must be the evidence of a witness who says he saw it. If the oral evidence which is produced in a case, that person who is producing that evidence, giving that evidence, has seen something with his eyes, it must be the evidence of that person who has seen with his eyes. That is where so much value is given. Especially in criminal cases, it is called as an eyewitness, a person who has witnessed with his eyes the occurrence of a particular act. Similarly, in civil cases also, if a person is giving evidence and the basis for that evidence is he has seen with his eyes, then that is called direct evidence. That has importance, that has value, that has weight. So if a person in the witness box says he has seen something, and if he is speaking about what he has saw it, that is an evidence which is relevant and which is direct. If he has not seen something, if he says something because somebody who has saw it has told him, then it is not direct evidence. So direct evidence should be, the oral evidence should be direct. And if it is the evidence of a person who has seen a particular fact, it is the evidence of that person and none else, because he has seen with his eyes. Then, if it refers to a fact which could be heard with his eyes, with his ears he has heard it, it must be the evidence of a witness who says he heard it. That is called direct evidence. Either you have seen it with your eyes, you have heard it, and what you have heard it, you are deposing, that gets weight, that is relevant, that is direct evidence, that carries weight. If you are saying something which you have not heard, which somebody else has heard it, and they have told you, then it is called what is known as hearsay evidence. Hearsay evidence is inadmissible as against the direct evidence of a person who has heard it. Then the third type of evidence is if it refers to a fact which could be perceived by any other sense. Eyes are all right, ears are all right. Any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense or in that manner. If he has felt something and he is deposing about that, then that is direct evidence. And then lastly, it also speaks about what is known as opinion evidence. That is evidence given by experts. If it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. So therefore, when we are talking about oral evidence, the oral evidence should be direct. And what is that direct oral evidence has been exhaustively dealt with under the Evidence Act. And if it does not satisfy the requirements of Section 59, then it is not admissible in evidence. So therefore, when you put a witness in the box, when you are deposing, when your witness is deposing, and if you are trying to prove a particular fact by oral evidence, the evidence person who is speaking in exam in chief, even by way of an evidence, is the person either who has seen it with his eyes, who has heard it with his eyes, who has perceived it, and from his personal knowledge, he is speaking that. Otherwise, it is what is known as hearsay evidence. It is inadmissible, and the opposite party can rightly object to even that evidence being recorded. By mistake, if it is recorded, and the argument can be pointed out, that evidence is to be excluded. It is inadmissible in evidence. On the basis of evidence, you cannot go into the question whether a particular fact is proved or not. And excluding that evidence, the court has to decide whether a particular fact is proved or not. So therefore, when we are talking about oral evidence, this is an aspect which has to be kept in mind. Now, as I said, in 1999 and 2002, exhaustive amendments have been made to the Civil Procedure Code, especially in the matter of recording of evidence. Now we saw what is oral evidence. Now that oral evidence is to be recorded in the court. If you say something anywhere, it is of no use. The party should enter the witness box take oath, and then he should evidence. As is clear from the Evidence Act, when the party speaks, it is his examining chief. Now, that examining chief, the mode of that examining chief has undergone a radical change. One of the reasons being undue time was being spent. Sometimes the examining chief was running to several days. And what he is going to say is already set in the plate. Probably that is the reason. Therefore, to cut short the trial, to encourage speedy trial, now the parliament in its wisdom has said, insofar as examining chief is concerned, it shall be by way of evidence. There is no necessity for them to enter the witness box and go on repeating what he has said in the plate. Probably that's what I have weighed in their mind. So therefore, what they have done is, they have exhaustively amended Order 18 Rule 4, which speaks about recording of evidence. So now what is the law? What is the change in the law? Now recording of evidence, when they made it, they did not see the effect of it on other provisions. Therefore, Supreme Court has to come to the rescue and harmonize some of these inconsistencies in Order 18. So before we go into the inconsistency, let us see what exactly is stated in Order 18 Rule 4. Order 18 Rule 4 speaks about recording of evidence, examination of witnesses. They enter the witness box and then court has to record the evidence. Now the question is how the court has to record this evidence, record this oral evidence, record the documentary evidence. Now let us first look into how court is expected to look into the oral evidence. Now the amendment brought about is this. Mark these words. In every case, the examination chief of a witness shall be on affidavit. Shall be on affidavit. So till this amendment, party or the witness is to be put in the witness box, and his lawyer would have conducted the examining chief, where the case of the party he would have spoken to. Now by this amendment they said, the examining chief of a witness shall be on affidavit. So whatever you would have said in the witness box on both, they say you make it in the form of an affidavit. Swear to it. And then copies thereof shall be supplied to the opposite party by the party who calls him for evidence. So the time spent in examination chief is today safe. Whatever you wanted to say in examining chief, say it in the affidavit. Get it sworn to. Give a copy to the other side so that he knows in advance what you have said. Therefore, he can get ready for cross-examination. This procedure, as the opening word suggests, in every case. Because in a civil trial, we have what is called as small causes case, small cause, long cause, a regular trial. And now we have Commercial Courts Act where evidence is recorded. Same thing is there in arbitration case. Arbitration case is nothing but a civil trial before an arbitrator. The rules are simplified, but this examining chief, cross-examination, re-examination is the same. There is no difference. So therefore, in every case, today as the law stands, examining chief of a witness shall be by way of an affidavit. Now, I said the evidence to be adduced is both oral and documentary evidence. What you wanted to say, you can put it in the form of an affidavit. But what about the documentary evidence? There is a prohibition for a person to say something which is adduced to writing, because you have to produce the document. Therefore, the proviso to this provision speaks about the documentary evidence, provided that where documents are filed, because along with the plaint, along with the written statement, the parties have to file all the documents on which they rely on. If they have produced Xerox copies, after the pleadings are complete, before issues are framed, you are expected to produce all the originals before the court. So, where documents are filed and the parties rely upon the documents, naturally, the proof and admissibility of such documents, which are filed along with affidavit, shall be subject to the orders of the court. So this makes a little elaborate in the sense, along with the plaintiff you produce documents, along with the written statement you produce documents. Now you are filing an affidavit of exam in chief. It says along with that affidavit, if you are also producing some documents, you can do so, but admissibility of this document is subject to the orders of the court. We saw earlier, court has the power to admit evidence. It may be oral evidence, it may be documentary evidence. If it is oral evidence, the party has to answer the questions of the court and say how it is relevant. Similarly, when documentary evidence is produced, if the other side were to object to the marking, production of the document, then they have to satisfy the court that the document is admissible. It has to be marked. So, when you are filing an affidavit, and if you along with the affidavit you produce all documents, where is the stage of objection? In the normal course, prior to this amendment, witness is to enter the witness box. He used to give evidence, and through him documents were marked. At the time of marking of the document, the other side could object, and the court was called upon to decide the admissible document at the stage and then proceed. Now that exam chief is by way of an affidavit, you are filing an affidavit, you are producing documents along with the affidavit, you also produce documents along with the pleadings, and what is the stage where the other side could object to it? That will come to it later. Therefore, the amended provisions of Order 18, Rule 4 makes it very clear how oral evidence and documentary evidence is to be adduced in every case. Now, having said that in every case, you please read 5. It makes a difference. What is the difference? It speaks about how evidence shall be taken in appealable cases. Order 18, Rule 4 said in every case. Every case also includes appealable cases. A very broad provision. Now, while amending that provision, probably the legislature did not look into this provision. It specifically says how evidence will be taken in appealable cases. This is not amended. Now, what it says is, in cases in which an appeal is allowed, that is, appeal is allowed against the judgment and decree passed in the suit, the evidence of each witness shall be taken down in the language of the court, in writing, taken down in the language of the court, in writing, by or in the presence or under the personal direction and superintendence of the judge, or from the dictation of the judge directly on a typewriter. Present day generation does not understand this. When we entered the profession, even typing was scarce and the typist was not available. Judge used to take down the evidence in his own handwriting. Then came the typewriter. Today we have the computers. But one thing certain is, evidence is to be recorded in open court. It should be in writing. It may be to the dictation of the typewriter, the stenographer. And then the judge signs it, party signs it. That is what they mean by saying taken down in the language of the court. Every court has its own language, and it should be recorded in that language, reduced into writing, and then it is typed on a typewriter or a computer to the dictation of the judge. This is the procedure prescribed in the Civil Procedure Code. This is the procedure which is followed in arbitration cases also. This is the procedure which is followed even in commercial, under the Commercial Courts Act. This is the way in which an evidence is to be recorded, because it is to be done openly, broad daylight. Everybody hears what the witness said. Everybody hears whether that what witness has said has been properly translated or dictated. And after dictation, again, the party has the right to look into and find out whether what he has said has been properly typed, and then only if it is right, he will sign it. And judge also will sign it. So this is the fairness, openness of a civil court trial. Nothing is done in a clandestine manner. Everything done in open. It is done in public. And that is the reason why the court proceedings command that respect. And therefore, everybody should keep in mind, this is what has enhanced the respect of the civil courts. Whatever is done it openly. Everybody could see it. There is no hanky-panky. Nothing is done behind the scenes. And that is the fairness which has brought good name to the civil trial. Now, once the evidence is recorded in this fashion, as I said, this is the way evidence is recorded in the civil court, whether it's a small cause case, whether it's a long cause case, whether it's a commercial court case, or even in a case before the arbitrators, Now, there is another interesting provision, Order 18, Rule 13. We saw 5 appealable cases. 13 speaks about memorandum of evidence in unappealable cases. That is small cause cases. Distinction is, if the judgment and decree passed by a court is appealable, it is long cause. No appeal lies, only revision lies, it is a small cause case. Broadly, we can say so. Now, as far as arbitration is concerned, no appeal lies. A 34 petition. And that's more the reason why the evidence should be recorded in a proper manner as if it's an appealable case. Exhaustively, it should be done. Similarly, it is done in the commercial courts also. This Order 18 Rule 13 speaks about memorandum of evidence in unappealable cases. It says, in cases in which an appeal is not allowed, it shall not be necessary to take down or dictate or record the evidence of the witnesses at length. Normally, whatever the witness says, it is recorded in his own language, if possible. There is no scope for condensing it. But in the case of unappealable cases, it shall not be necessary to take down or dictate or record the evidence of the witness at length. But the judge, as the examination of each witness proceeds, shall make a in writing or dictate directly on the typewriter or cause to be mechanically recorded a memorandum of the substance of what the witness deposes. And such memorandum shall be signed by the judge or otherwise authenticated and shall form part of the record. In appealable cases, a question is put, answer is given, and that answer is taken. If there is an objection regarding marking question itself, the question is typed, answer is typed. But in unappealable cases, the judge need not do that. You can ask the lawyer to put questions, not one question, 2, 3, 4 questions. And he has heard the answers and he can summarize them and put the summary. That's the difference between recording of an evidence in appealable cases and in unappealable cases. Now, this has been the subject matter of a dispute. While the constitutional validity of these provisions were challenged before the Supreme Court in the famous Salem Advocates Association case. Now, what the Supreme Court has said is it has tried to harmonize these two provisions. In every case, it is by affidavit. In appealable cases, it should be in writing. How do you reconcile? The way the Supreme Court has reconciled and today what is followed in all courts is you put the witness in the box. He hands out the affidavit, which contains the examining chief. In appealable cases, normally, the judge will put a question to him, or the lawyer will put a question to him. Is it your affidavit? Is it duly sworn to by you? Is the fact stated herein as true? Judge records it. That is compliance of Order 18 Rule 5. Then the affidavit is taken. then the cross-examination goes on. So that's how an attempt is made to reconcile Order 18, Rule 4, where the word used is in every case, Order 18, Rule 5, where in appealable cases, that is to be reduced into writing by the judge to the dictation. Anyhow, broadly, this procedure is followed, I am sure, all over the country, and I think it is doing well. But the fact remains, after the 1999 amendment to the Civil Procedure Code, today the examiner-in-chief, at least of the party, is by way of an affidavit. Then the question arises when you want to examine a witness, an official witness. Who has to prepare the affidavit? He will say, I am not going to say anything in advance. I will say whatever I want to say in the court. Therefore, the court said, this rule applies only to the parties and to any other witness who is willing to file an affidavit. You can't compel him. If that person were to say, no, I will come to the court, I will, in the witness box, I will say whatever I want, then his examination in chief is to be recorded in writing in the court, and then he should be permitted to cross-examine. So strictly speaking, this filing of affidavit is confined only to the party and to the witnesses are willing to consent for the procedure. If they are not giving their consent, the Supreme Court said, come on, put him in the witness box, examine in chief, then cross-examination, that is permissible. So that's how the Supreme Court has tried to harmonize these two provisions. And now I think more than a decade is over, we are recording the evidence in that particular matter, and today we have no problem. Now we have the Commercial Court Act. As I said, today, what is this affidavit in chief, exam in chief? Whatever is stated in the plaint or in the arbitration case, whatever is stated in the petition is converted into an affidavit. While discussing the law of pleadings, I said plaint or written statement should contain only the plea and plea alone. Evidence is impermissible. But unfortunately today the practice has developed not only in Karnataka, throughout the country as I could see. The pleadings includes the plea, evidence, statutory provisions, judgments of the courts, even arguments. That's why it's so bulky. When they convert it into an affidavit, the entire thing is there. That's one of the reasons why the records are so bulky. This factor has been taken note of. That's all. That is the procedure followed even in arbitration cases. That is why in arbitration cases, especially, we have bundles and bundles of pleadings. That is not the object of arbitration. Many times we will not know what the case itself, because it runs to thousands of pages of pleadings. Now the parliament has taken note of this. And when they are talking about commercial courts, they have come down heavily on this practice. What is that they have done? Now the Commercial Courts Act, which deals with a power is conferred on the court first to have a case management hearing, says if an affidavit filed by the parties by way of exam in chief contains plea, evidence, arguments, statutory provisions, judgments, court is not powerless. Now, what is the power conferred on the court as far as commercial courts are concerned? This is a provision which is a part of Civil Procedure Code as applicable to commercial courts. 2015 of the amendment, the Civil Procedure Code amendment, as applicable to commercial courts only. It says, reject any affidavit of evidence. Reject any affidavit of evidence filed by the parties containing irrelevant, inadmissible, or argumentative material. That affidavit should contain the plea and the evidence. Pleadings should contain only the plea. This affidavit in exam in chief should contain plea and evidence. But it should not contain irrelevant, inadmissible, or argumentative material. Before this law, if the party were to adduce some irrelevant evidence, we saw Section 148 of the Evidence Act conferred upon the court to call upon them to explain the relevancy, and if it is not explained, refuse to record evidence. When you file an affidavit, an opportunity is lost. Therefore, now this law says, reject any affidavit of evidence filed by the parties containing irrelevant, inadmissible, or argumentative material. So power is conferred on the court to reject that affidavit outright. So this is not in conformity with law. It contains all these things, and therefore I will not take it on record. Bring the affidavit in conformity with the law. That is, plea and affidavit, nothing else. An option is given. Strike off any parts of the affidavit of evidence. Strike off any parts of the affidavit of evidence filed by the parties containing irrelevant, inadmissible, or argumentative material. So take a pencil, red pencil, read the affidavit, strike off all those paragraphs which contains irrelevant, inadmissible, or argumentative material, and then call upon the party to confine his cross-examination only to those portions which are not struck off. Thereby, precious time of public money, precious time of courts, even precious time of the parties is saved. When you file an affidavit sworn to, and if no cross-examination is done on any particular aspect, the argument would be this has remained unchallenged in cross-examination. To avoid that argument, cross-examination went on irrelevant material, inadmissible material, argumentative material. If the judge were to object to it at the stage, the argument would be, I will say what is the relevancy at the final stages. And that's how this evidence recording became a laughing stock. And the evidence recorded was so voluminous. In the end of the day, 90% of the evidence was not relevant to the case. So this has been taken note of by the Parliament, and they have rightly brought in this amendment in the 2015 amendment to the CPC, but they have confined it to only commercial courts. And I would believe most of the arbitration matters are all which fall under commercial courts, commercial disputes, breach of contract, recovery of money, damages by two industrialists or businessmen, traders, contractors. This provision should apply so that the courts and the arbitrators would be able to concentrate on the real matters in controversy and effectively deal with the matter and decide the disputes at the earliest. Otherwise, this voluminous unwanted material, which is brought in by way of first pleadings and then by evidence, would very defeat the very purpose of these amendments. So therefore, today, when we are talking about a recording of evidence, keeping in mind the amendment to the law, it may be a long cause, it may be a small cause, it may be arbitration matter, it may be a commercial court. The law is well settled. It is by way of an affidavit. Affidavit should contain only the plea. If it does not contain plea and evidence and something else, in the commercial court cases, court has the power either to reject the affidavit or strike off those unnecessary pleadings. So therefore, a lawyer who takes pleasure in this trial work, trial is an art. To be effective, you must have these principles on your fingertips and implement it in your regular work so that the desired effect of this could be seen. In fact, in the Commercial Courts Act, now what they have said is, once the schedule, case management hearing schedule is fixed, please see what this amendment says is what is done in the arbitration case. In the arbitration case, after the arbitrator is appointed, in the first hearing, with the consent of the parties, a schedule is fixed. In the court, case is posted for issue notice, written statement, extension of time, written statement filed, then posted for issues, then posted for production of documents. These are the stages. all those stages are gone. In the arbitration case, by the time the case is ready for case management hearing, pleadings are complete, interrogatories are all answered, admission and denial of documents is there, issues are framed, and then the case comes up before hearing. And in the case management, now you are called upon to fix the hearing. Evidence of the plaintiff, filing of affidavits, cross-examination, written arguments, oral arguments, everything. Date is fixed. Before this, in the arbitration, that is what is done. In the first hearing, a schedule was fixed. Claimant to file the statement of claim within a particular date. Then respondent to file his counter, defense. And then the claimant to file his reply. And if there is a counter claim, then the defendant, the respondent to file his written statement. Dates are fixed. Then date is fixed for filing application of interrogatories. Then date is fixed for production of filing of affidavits of admission and denial. And then the case is fixed for framing of issues. And then filing of affidavit in exam in chief, cross-examination, then arguments. That provision, that procedure, which was followed in arbitration cases, today finds statutory recognition by way of an amendment to the Civil Procedure Code. Insofar as commercial courts are concerned, they call it as case management hearing. In that case management hearing, all these dates are fixed. And now the outer limit is, that is the beauty. You can go on fixing the dates for 2 years. No. Now the case management rule says time limit for the completion of trial. In fixing dates or setting the time limits for the purpose of Rule 2 of this order, the court shall ensure that the arguments are closed not later than 6 months from the date of the first case management hearing. So when the case management hearing is fixed, in that fix, you are producing a schedule. You must fix the dates in such a manner that the hearing is completed within 6 months from the date of the case management hearing. So all this has to be done within 6 months. And then they have said, the court shall, as far as possible, ensure that the recording of evidence should be carried on day-to-day basis until the cross-examination of all the witnesses is complete. So what is contained in the Civil Procedure Code now has been brought into the Commercial Courts Act also with a specific case that the evidence to be recorded shall be recorded on day-to-day basis. That is how even the Arbitration Act says. So tomorrow we'll continue with the rest of the trial. Thank you.
So the more we listen, the more fascinated we become as to how, without even a touch to the paper, you can take us through the entire journey as to how one has to learn. Before we take the questions, sir, since the participants are watching us live on the Facebook as well as this, just for the participants, what tomorrow we will discuss about, just a bird eye view on that. 2-3 sub-agendas, what we will be taking up tomorrow.
Tomorrow I will be dealing with the documentary evidence, production of documentary evidence, objection normally taken for production of documents, how that objection has to be dealt with, especially regarding stamp duty and also regarding registration, and then the arguments. That will complete the trial.
Right, because I said you have explained in an elaborative manner. The impression might not be that everything has been covered today. Then what we will have to look in tomorrow.
Only 50% I have covered. The remainder 50% tomorrow.
No, I understand, because once we discuss that, we will have 2 sessions on this thing. Yes. So this is by Dharmender Parmar. In examination in chief, witness is hostile. Is his evidence valid?
If the witness turns hostile, the law provides for his cross-examination by the persons who called him for evidence with the permission of the court. And after his cross-examination with the very party, it is for the court to appreciate that evidence. Merely because the witness has turned hostile, it is not as if that the entire evidence is to be ignored. So it all depends upon the facts of the case, on what aspects he has given evidence, on what aspects he has let down the party who is examining.
Yeah. Chandrakant Dawani, we generally see many times defendants fail to file written statement. So what is the strategy according to you that the plaintiff should proceed? Should the plaintiff directly ask the court to give judgment under Order 8, Rule 10 on admission, as there is no denial, or plaintiff should lead the evidence to prove his case and proceed ex parte and get ex parte decree?
Though the court is to grant a decree on the ground that the written statement is not filed, in practice, no court will do that. As I said, even if a fact is admitted, court has the power to call upon the party to prove to their satisfaction. Therefore, normally, when written statement is not filed, though in law, the plaintiff allegations are deemed to have been admitted, the court is not bound to pass a decree straight away. Normally, they call upon the plaintiff to produce evidence. The standard of proof that is required may be different. Only after he produces the document, because the law requires a suit cannot be decreed merely on the ground that the written statement is not filed. Even if it is an ex parte decree, judge is expected to set out in his judgment what is the facts of the case, then refer to the defendant being absent, then say what is the point for consideration. No issues because no written statement is filed, and then looking into the evidence on record, he has to give a finding. Therefore, normally, generally, no court will pass a decree saying suit is decreed because the written statement is not filed. They have to write a considered judgment. For them to write a considered judgment, this is the procedure.
This is by Ayushi Mishra. Should the demeanor of the witness also be recorded if it hasn't been recorded and not subsequently being signed by the witness? Can it be used as a basis of judgment?
There is nothing like the witness signing his demeanor. Demeanor is watched by the trial court. The court has to record a finding at the time of judgment, whether that evidence of that witness could be believed or not. If the judge has watched the demeanor of the witness, the way he has answered, the way he has refused to answer, the way he conducted himself in the witness box, his mannerism, all go into the mind of the judge before he records a finding. Here is a witness whom he can rely upon or who cannot rely upon. Sometimes it so happens the judge has the liberty to make a note in the order sheet saying this is how the witness was behaving in the witness box, because there is possibility that after he records it, he may not be able to write a judgment. So if demeanor is noted, not only he did not strain his memory, it will come to his mind the moment he reads it. That goes a long way. Question of witness signing the demeanors will not attend. That is why he said, if a finding is recorded by a trial judge purely based on the oral evidence of the witnesses, though the first appellate court is the final court on facts, if the appellate court can come to a different conclusion than the trial court, if two reasons are possible, the first appellate court should not interfere with the finding recorded by the trial court, because the appellate court did not have the opportunity of watching the demeanor. Therefore, the trial court finding gains weight because he has observed the witness, observed the demeanor of the witness, and then he has recorded a finding on appreciating the oral evidence.
Yes. This is by A. Kumar. Affidavit in lieu of examination chief affirmed by plaintiff and tendered by her advocate simultaneously with original documents. Plaintiff did not enter in the witness box, marked only the admitted documents and did not mark the other original documents. What is the way forward for that?
Procedure is wholly illegal. The witness should enter the witness box. He should hand over the affidavit. And through him, you cannot mark the documents in the affidavit. Exam chief, oral evidence, that's all what it should contain. You may refer to the documents in the exam chief, but marking of the document should be done in the open court and giving an opportunity to the opposite party to object to it. Otherwise, the procedure followed in recording documentary evidence is incorrect, and if the plaintiff witness has not entered the witness box, there is no evidence at all. He should enter the witness box, he should be administered the oath, and then he must hand over the witness. Then only it can be examined chief. It is not exchanging of examined chief by lawyers.
So this, according to you, would also play the same procedure for the arbitration under the Arbitration Act also? Because normally we simply sit and give the affidavit.
You give the affidavit, but when we are recording the evidence, he should hand over it. See, sometimes it so happens, the witness, you show it to him, he says it is not my affidavit at all. Then what will you do? Whole thing will collapse. You should not reduce yourself to the stage. The witness should hand over, this is my affidavit. You give him the paper, he will say it is not my affidavit at all. Even in the arbitration, witness is given administered oath, and then he should say it is my exam chief. In arbitration, the mode of recording of evidence is the same whether it is civil court or arbitration. Arbitration Act do not provide any separate procedure. And this procedure, there is no reason why it should be dispensed with, because it does not consume any extra time. The sanctity of a trial depends upon these proceedings. That's why our trials are respected, our courts are respected. Any attempt to give away this procedure will destroy the name and fame of the judicial system. Because nobody need waste their time. This is how it should be done.
This is by Stan Lewis. In a will case, the property derived from the ancestor's property, the plaintiff submitted documentary evidence, but the defendant has no evidence to prove. Simply says that the property bought by the through selling of the jewelry. In the cross-examination, the defendant says the property is self-acquired / earned property. In the re-examination, he accepts the property was brought through selling of the ancestor's property. How to deal in such a situation?
It is a question of appreciation of evidence left to the judge. He is doing different versions. It is an appreciation of evidence.
So Praveen Kumar says, is it permissible if a party files an affidavit in lieu of his examination chief without pleadings and evidence, but stating that the contents of plaint shall be read as part of his affidavit?
First, there should be a plea. Then he is giving evidence. If he has not filed any pleadings at all, he has no right to give evidence. He can cross-examine the opposite party. If the written statement is not filed, he cannot lead evidence. Without filing written statement, he can cross-examine the plaintiff witnesses. Now, it is open to the plaintiff how the evidence is to be drafted. He can say all the averments in the plaint may be read as part and parcel of this affidavit also. If that is how he wants to do it, nobody can find fault with this. And then he runs the risk. At least at the time of giving evidence, the lawyer and the party should apply their mind and find out what evidence they should adduce, what evidence they should not adduce. And if they are plainly following, that's what I told you, plaint contains arguments, evidence, because plaint should contain only plea. This exam chief affidavit should contain plea and evidence. So God only knows what that plaint contains. So merely because saying, I adopt all these statements in the plaint, that itself will not make it a evidence at all. Evidence is different from plea. Strictly speaking, plaint contains plea. Now, when you are leading evidence, you must lead what the evidence is.
So I take a step forward. In large number of cases, we have seen that it normally happens is that instead of a detailed written statement being filed, it says that the facts word in the petition or plaint may be read as travesty of facts. However, at this stage, they are filing a short affidavit, but they have not specifically dealt each para-wise. So what will be the position on law in that particular situation? Because they have just summarized their entire case in a short affidavit. At least in the writ petition, I've seen this is the new style of drafting of the reply.
Order 8, 5, 6. And now the commercial court says it is no denial at all.
So that would be admitted to be deemed to have been admitted.
Yes.
The last question by SJ is, if witness is asked a question, where answer is expected yes or no. However, he starts telling the story. What remedy does the cross-examiner have in such a situation?
Well, that is what is now we see in the court. The courts can interfere and tell them to be specific. But at the same time, you cannot compel the witness to say yes or no. You cannot compel the witness to say, I put a question to you, you simply say yes or no. That is not permissible. At the same time, he cannot go on giving lectures in the courtroom. There, the court's role will come into a play, and the court can direct him to be specific as far as the answer is concerned.
Thank you, sir. All the questions have come in, whatever have been asked. So thank you on behalf of all the participants who are watching us live on the Facebook. But thereafter, I will share with the screenshot with you. But I expect that today will be the maximum number what has come on the Facebook so far in our webinars. And as usual, your insights given was very concise, precise, and incisive. And we have actually enjoyed the manner in which you have expressed. And tomorrow, as today's session was reflecting, it was master class 1 of examination of witnesses, civil trial and arbitration act. And as Justice N. Kumar has already given, that tomorrow he would be dealing the manner and procedure in respect of the documentary evidence. So do stay connected with us for tomorrow's webinar. But timing would be 4 p.m. since it's a weekday. Everyone stay safe, stay blessed. And on behalf of all the participants who are watching us live on the Facebook as well as on this platform, thank you to Justice N. Kumar. And also on behalf of the participants who will watch our YouTube channel of BeyondLawCLC, wherein this video would be uploaded. If those who have not subscribed, they can subscribe to our channel for the previous webinars, including of Justice N. Kumar, which have already been uploaded. Thank you, everyone. Jai Hind. Namaskar. Thank you, sir. Have a good day.